Welcome everyone today to our first webinar of the year.
Yes.
We're going to be talking about the Property Practitioners Act. With me in studio, I've got Jade Matembo, our General Counsel, and she's going to be facilitating our questions and answers. Of course, I've also got Peter Menon, our Head of Legal, with me today. And Peter, we've got a lot to get through.
We do, Michelle.
But who would have thought coming out of our December holidays, we would have been given 2 weeks' notice to get ourselves prepared and ready for the Property Practitioners Act, and more importantly, 30 new documents.
Michelle, there has been a lot of reading, a lot of studying, a lot of looking at the legislation, a lot of late nights, and of course, a lot of amendments to the documentation packs that we've got available to clients.
So we've got our lease pack, both on the residential, the commercial, and the sales pack. Jade, yourself, Greg, Justin, Peter, and Nikki, the 5 of you have put together 30 new documents, or amended 30 documents, added 2 new documents. And those documents are available on the shop, on the lease pack websites immediately as of this morning.
Yes.
So our existing lease pack members can go in and download those new documents.
And also, if you're a subscriber to the e-sign system, all of those documents on the leases, as well as your mandates, and now the mandatory disclosure form is also available to you on the e-sign platform to utilize.
So those are electronic signatures.
Yes.
Free to use electronic signatures.
Correct.
For our members who are members of lease pack and sales pack.
Correct.
Okay, so let's talk a little bit about the housekeeping, Peter, before we get going.
Perfect. Thank you very much, Michelle. You need to be logged in to be able to access the chat on the right-hand side of the screen. So log into YouTube at this moment in time, and then you can access that chat. Remember, you can ask your questions throughout this session. Jade is hopefully going to be interrupting us with a lot of questions today on the Act and regulations, but we are also running a 15-minute Q&A session right at the end that we're going to be providing feedback forms to you. Very importantly, for your unverified CBD points, as well as our own feedback on new sessions, on different sessions that you'd like throughout the year. So please go and fill out those feedback forms for us. And lastly, if we seem a little bit blurry, we didn't all get dressed up in black this morning. It was telepathic actually, but go and click on the cog right down at the bottom of the right hand side of your screen and go and select 720p or higher, and then we're going to look much better on your screen today.
So Peter, let's jump into then what we're going to be dealing with today.
Yes.
We're going to be, I mean, the Act speaks about transformation, it speaks about regularization, but we're going to limit our conversation today around who needs to register as a property practitioner.
Vital.
What the exclusions and the disqualifications are, how our property practitioners will go about registering, what we need to implement today, to start implementing today in order to be ready for that registration on the 31st of October. And then importantly, we're going to talk a little bit at the end about what's changed in terms of those documentations, in terms of those 30 different documents, and the implementation from the 1st of February in terms of this mandatory disclosure form.
Yes, so really practical steps today in getting yourself ready for the 1st of February, as well as your registration at the end of the year.
Okay, so Peter, let's jump in. Who needs to register as a property practitioner? Because there's this definition of property practitioner in terms of the Act, and then in terms of the regulations, there's this definition of estate agents.
Estate agent, managing agent, homeowners association. The only thing that hasn't been defined for us is bond broker, which we'll be discussing now as we're going through the definition of a property practitioner. A property practitioner is any person who on behalf of somebody else sells or leases out or manages a property. So that would include all estate agents currently that is busy working as estate agents under the Estate Agency Affairs Act.
So that's the definition of an estate agent.
Yes.
We've then got this definition of a managing agent. Yes. And a managing agent is also then defined as being a property practitioner.
Yes, most certainly. So a managing agent would also fall under these definitions, not just in terms of the Act, but also in terms of the regulations. Then you've also got commercial brokerages, which will also fall under the definition, as well as different professions like a property valuer and a property inspector. The nuance comes in, however, and we've read a lot of opinion pieces about this already, is a bond broker.
Which is not defined.
It's not defined. And usually we say bond origination or a mortgage originator, all of these. But in terms of the definition, it would seem to us as if a bond broker, bond originator would not fall under the definitions of a property practitioner, but we obviously need more clarification on this. It's a little bit grey because a bond broker is defined as a person or a company that is registered in terms of the Financial Sector Regulation Act, in terms of that Section 1. So it's very possible that they would not fall under the definition of a property practitioner.
There's
Yes,
an exclusion
correct.
in terms of that additional registration. Yes. What are the exclusions, Peter, then? So we've got these property practitioners, we've spoken about it, it's people that sell property on behalf of another. So if I'm a private person selling my own property, or I'm a private landlord renting my own property, do I need to register as a property practitioner?
No, you would not. That is in the ordinary course of business as a owner of a property to rent out your own property or to sell your property.
Even if I have 1,000 properties in my portfolio that are my own properties that I want to rent, do I need to register as a property practitioner?
No, unless the person who is doing so, obviously, is receiving a commission or a remuneration that is not part of your business. Then that person or that company would need to register as a property practitioner.
What about if I'm a developer and I've developed properties to sell? Would I need to register as a property practitioner?
Also, a little bit of nuance over here. It seems like you would not need to register as a property practitioner yourself, but it is possible in certain instances, once again, like I just mentioned, if a person is receiving remuneration or commission for doing that work as a sales agent or as a rental agent, that party would need to register. Also, Michelle, for attorneys in terms of the Labour Practice Act, or the Legal Practice Act rather, those attorneys and candidate attorneys would not need to do so because they are regulated by that act already. However, if they've got an employee that is not an attorney or a candidate attorney, that person would need to register through the Property Practitioners Regulatory Authority and have their FFC done.
If that person's responsibility, job position was that of selling or renting or managing, collecting monies in terms of a lease agreement.
That is.
If that person's job function was that, then that person who's not a registered attorney or candidate attorney would need to register as a property practitioner.
That is 100% correct.
Okay. What about the disqualifications, Peter? Who is disqualified then from being a property practitioner?
Michelle, before we get into that, I see Jade's busy waving her hand on this side. So let's take a question on that section.
We do have two questions right off the back. Question from Retirement SA, Marilise van Rooyen. What about a retirement village with staff members selling or leasing units? Are they also seen as property practitioners?
It would very possibly be so if they are performing the acts for remuneration or commission, and it is not specifically their own properties or the properties of that person that they own. They would have to register with the Property Practitioners Regulatory Authority, yes.
And then I have a follow-up question from Diana. Does a developer need to register?
I've seen a number of articles on this and seen a little bit of difference in this. There has been an article that said that developers might need to register in certain instances to be able to sell their own properties or to lease out their own properties. I don't think the Act takes that definition as far as what those articles suggest. It is a possibility, but we'll probably see on the 31st of October when those registrations need to happen, who actually needs to register specifically from those points. Yes.
Thank you.
Only a pleasure.
Okay, so jumping back into disqualifications,
Yes.
Peter. The Act says that in certain instances, the authority may disqualify under certain circumstances,
Yes.
The registration of a property practitioner. Run me through some of those disqualifications.
Michelle, you gave me a full list right before we started, so I'm going to try and remember all of these. But a person who is not a citizen of South Africa and not a resident of South Africa could be disqualified in terms of the Act. A person of an unsound mind, a person without a BE certificate or a valid tax clearance certificate, as well as a person who's been convicted of a criminal conviction or in the last 5 years has been dismissed from a position of trust would need or could possibly not get an FFC through the regulatory or the Board of Authority.
Right, so there's some changes there
Yes.
then in terms of the requirement of a valid tax clearance certificate
Yes.
and the requirement in terms of needing a BEE certificate as well. And we're going to talk about that in a moment.
We will.
So we've spoken about who needs to register. We've spoken about the fact that we have estate agents that currently have an FFC, Peter. What does that mean in terms of registration, and when do people need to start applying?
So the great thing is, in terms of Schedule 5 of the regulations, we've got this transitional arrangements, which means that any estate agency currently or estate agent who has a valid FFC will have that FFC for the duration of this year. However, with registration, that would need to occur before the 31st of October of this year to register with the Property Practitioners Regulatory Authority, as well as get your FFC directly through them. The wonderful thing about the FFC, however, is that FFC is going to be valid for a period of 3 years rather than the current period of 1 year that we have, as well as if you change positions or you change jobs as an estate agent or a property practitioner, that Fidelity Fund certificate would still be valid in terms of the Act, because they're not going to put positions directly on those Fidelity Fund certificates.
So the Fidelity Fund certificate is going to last for a period of 3 years. Our estate agents and new property practitioners would need to register on the 31st of October. What about estate agents who are currently practicing but not registered? Is there any grace period for those non-compliant estate agents at the moment?
That's a great question. So they are currently not liable or not guilty of an offence if they have not registered as an estate agent or an estate agency. However, there has been a lead time given for that party to register within a period of 6 months of the effective date of the 1st of February, and they would need to have a valid FFC 12 months thereafter. So that obviously means through the different types of training that we had in the previous Act, like your NQF4s, your NQF SIP5s, they would need to write a PDE, your professional designation exam, which will set them up to be able to register as a property practitioner and get that valid Fidelity Fund certificate through the authority.
But they're going to need to do that within the next 6 months
Most
period.
certainly, yes.
Peter, how do our future property practitioners prepare themselves to register on the 31st of October?
I'm still having difficulty going estate agent, property practitioner. Michelle, there is a number of things that we believe every property practitioner, estate agency currently needs to do in their business. Like we alluded to, with the registration from the 31st of October, every property practitioner business or business property practitioner would need to have a valid BEE certificate as well as a valid tax clearance certificate. Furthermore, they would need to have their trust accounts audited 6 months after the financial year end and provide details of the auditor as well as those audited accounts directly to the authority for registration. So there's a lot of technicality or rather administrative matters that needs to be handled prior to you being granted your Fidelity Fund certificate.
So let's talk through some of those. I mean,
Yes.
The first one is that if your turnover is less than 2.5 million rand, you don't need to be audited. You can now have a review of your financial statements by a qualified accountant.
Correct, Michelle.
Or registered
Yes.
accountant. So we've got this review process. Also, in terms of the Act, it makes provisions for property practitioners who don't receive money into their trust accounts. So in terms of the Estate Agency Affairs Act, every single estate agent was required to have a trust account,
Yes.
whether or not they were receiving
And pay
funds,
bank charges on those.
right, and get them audited. So in terms of the New Property Practitioners Act, estate agents or property practitioners who don't receive funds into their trust account can apply for an exemption, which means that they don't need to have a trust account, and that trust account that they don't have won't need to be audited. So there's a bit of fee saving
Yes.
over there as well.
And this would obviously include property practitioners who are using intermediary services or trust accounts by attorneys to run their business through. Then you wouldn't need to have those audited trust accounts or open a trust account in this matter.
Okay, and of course, both our property practitioners who are the business and the property practitioners who are natural persons will need a valid tax clearance certificate. So it's imperative to get your tax affairs in order so that you can get your tax clearance certificate prior to the 31st of October when registration happens.
Most certainly, Michelle.
And of course, a valid BEE certificate.
Yes.
And again, that is a process based on your last set of financial statements, audited financial statements, and you will need to be audited through your BEE auditor in terms to get that certificate. Again, has to be finalized prior to the 31st of October when registration opens.
And I think that's a very good practical stopping point, because just looking at ourselves with our BE process, it actually takes a while to do. So you definitely need to start that process sooner rather than later. Also with marketing material, and this is also a little bit of a change in the Act, is that with marketing material, and marketing material could basically mean anything. It could be on your website, samples, your pamphlets, emails, all of those marketing materials that you're currently busy utilizing for sales or rentals to market a specific property to try and get a tenant or a potential purchaser of a property, they would need to have on that marketing material registered with the Property Practitioners Regulatory Authority. So that's very important. That's something we can all start doing now, and that obviously is not going to kick in on the 31st of October. That's going to kick in from the effective date of the 1st of February of this year. So that's a definite change that all property practitioners need to make at this point in time.
And do they need to include their Fidelity Fund registration number on all of that material as well, Peter?
Not on the marketing material per se, but it would need to go in certain agreements, which we're going to talk to now, I'm sure, but not necessarily on your marketing material. In terms of the regulations, that is a specific sentence that is used in the regulations that needs to be placed on all that marketing material.
Well, let's talk a little bit about those documents. So we changed 30 different documents. Yes. And Peter, Jade, you were involved. Some of those documents that we changed were small changes.
Yes.
They seem like small changes. A lot of definition changes were included as well. Inserting of the Fidelity Fund certificate, inserting on whether or not you have attached this mandatory disclosure form. Let's talk about those changes first, and then let's jump into this mandatory disclosure form.
Perfect. Michelle, before we get going, I forgot to mention something in the previous section, if you wouldn't mind. Thank you. With the Fidelity Fund certificates, they need to be placed at the place of business. So with your place of business, it is obviously your physical premises, but we had a discussion about this yesterday. It could also include your websites and those platforms. So we would actually suggest having a copy of the Fidelity Fund certificate, not just available at the place of business, but also where transactions are occurring. So
Absolutely.
that might be your own internal system that you're utilizing, placing properties for sale or for rental on that system as well.
So let's talk about those documents. Those
Yes.
documents are all on the shop.tpn.co.za. There are 30 of the new documents. We've clearly noted which of the documents are new versions, and with the version control, and we've popped the date in. So our existing lease pack and sales pack members will be able to access those new documents and download them. Talk me through the changes, Peter.
Okay, so I believe if I've got the numbers right here, we've changed 13 documents on the sales pack, we've changed 9 on the residential lease pack, and 10 documents on the commercial lease pack. Before we get into the mandatory disclosure forms, because I think this is going to be a very big discussion that we need to have today, because it's something that we all need to implement right now. But the smaller changes, like you mentioned,
and the consequences of not doing
Yes,
it are actually quite severe.
Most certainly. The smaller changes you mentioned, I love the word smaller changes, because for everybody it seems like, oh, there were such small changes made, but changing the word estate agent into property practitioner actually takes a while on all of these documents. We've also amended the definitions from the Estate Agency Affairs Board to obviously the Property Practitioners Regulatory Authority, the Estate Agency Affairs Act into the Property Practitioners Act, and then change all the definitions of estate agent into your property practitioner. My word, I just lost my train of thought. I'm thinking exactly what we changed on the documents. Then with smaller changes that we've also made, is we have to include in all of your agreements with your landlords, or even with your OTPs, your office to purchase, thank you, your lease agreements, a specific clause that says that the property practitioner verifies the validity of their Fidelity Fund certificate as at the signature date of the agreement. So that's now been included in the mandates, as well as all the office to purchase and your lease agreements.
Because effectively, a property practitioner is not entitled to receive or claim any commission if they do not have a valid Fidelity Fund certificate.
No, most certainly not. In terms of the Act, you're not allowed commission whatsoever, and you've actually got to pay the commission that you've received back
to the authority.
In terms of those regulations. Michelle, schedule changes that's also been made on the documents, and this is across the board on sales pack as well as residential and commercial lease pack, is that we've included a schedule change that says mandatory disclosure form, yes or no. We obviously know in terms of all the sale agreements, perhaps for individual landlords listening today, they don't need to be compliant with the Property Practitioners Act. However, the mandatory disclosure form tick box is incredibly important for the estate agents.
Okay, so I just want to take a step back
Yes.
and make sure that I fully understand and we're getting the message across properly. In terms of an offer to purchase, it can be an offer to purchase which is facilitated by an estate agent,
Yes.
or it can be an offer to purchase which is a private sale between a buyer and a seller.
Correct.
On both of those offer to purchases, we've put in there the option that says mandatory disclosure form, yes or no, that can be ticked. Where it is a private sale, it doesn't need to be included.
No.
But we suggest it's included because if there is a dispute over a latent or patent defect,
Good.
that might save some legal costs.
Most certainly.
In terms of the offer to purchase, which is facilitated by a property practitioner, that mandatory disclosure, yes or no, the mandatory disclosure form, which we've given the option of is attached or not attached, by law must be attached.
Yes.
And forms part of that mandate.
I think it can be utilized as a checklist rather than anything else. Because in terms of your mandatory disclosure forms, that mandatory disclosure form needs to be given by a landlord or by the seller of the property prior to the estate agency entering into the mandate agreement with the owner. Now, the issue with that is I actually had a discussion yesterday with an estate agent, a property practitioner, that asked me, but what happens with procurement deals? What happens with management deals? There hasn't been a difference in the Act when it comes to the term mandate. So even for procurement deals, you're going to need that mandatory disclosure form by the landlord prior to entering into the mandate with that specific party. I also think it's a nice little checkbox here because we've been working in the industry for quite a while, I may say this, but mandate agreements, whether they're procurement, whether they're managed, I think there's a lot of estate agencies that still don't fill out written procurement mandates or even fill out written management mandates. And I think it's a good checkbox system to have already to say that prior to entering into that agreement, because you can enter into a verbal obviously procurement mandate, not necessarily so a verbal management mandate, but to know that that mandatory disclosure form is a requirement in terms of the Act to have prior to entering into that mandate agreement with that specific party. It's absolutely vital.
Okay, let's talk about what's included in this mandatory disclosure form. What is the purpose of the mandatory disclosure form?
So the mandatory disclosure form was actually very easy to draft. I'll say this one. The reason being is that it's been included in the regulations as a form already. So it is already pro forma in the regulations that this is what the document needs to look like, and these are the conditions that needs to be attached to that specific document. So it speaks to the condition of the property. There's specific sections in that, looking at the roof, looking at different aspects of the property, and the landlord needs to go and mark those.
The landlord or the seller? In the instance of a sale?
The owner of the property, let's say that.
Yeah.
The owner of the property needs to go and mark those and what condition those specific aspects of the property is in. This would establish consumer protection, as they've called it in terms of the Act, because then a consumer, a prospective purchaser of the property, a prospective lessee rather, can go and have a look at this disclosure and see, okay, well, this is what's wrong with the property. Regardless, in the Act, it has also been stipulated that the prospective purchaser or this prospective lessee of the property is not precluded from having a look at the property himself to establish whether that mandatory disclosure form is actually correct. That they
so they could have a
given.
property inspector come in and do their own inspection on the property
Most
as well.
certainly, most certainly.
So it's a requirement in law. You've got to do the mandatory disclosure form if you're an estate agent. You've got to attach it to your mandate for sale or your mandate to lease.
Yes.
You've also got to attach it because it's got to be signed by the estate agent and the seller.
Yes.
Or the estate agent and the landlord.
By all parties involved.
And then it has to be signed by the tenant and attached to the actual lease or offer to sell as well.
Yes. So it needs to be attached to the lease agreement. It needs to be attached to the offer to purchase. This is going to become quite interesting with the rental scenario. I think that they might take this into consideration when we're busy getting the regulations to the Rental Housing Amendment Act. But what we've got when it comes to your mandatory disclosure forms is now it's obviously going to be a requirement in terms of your rentals, if it's a managed or a procurement deal from the estate agent, to attach this document, have the landlord sign, have the property practitioner sign, and have the tenant sign this. That this can be seen as a consideration of defects on the property but you're not precluded from still doing the incoming or outgoing inspections on the property. You still need to do them.
In fact, it's a requirement
It's
in
a
law that has to
requirement.
happen. So an incoming, a joint
Yes.
incoming inspection must still be performed, and a joint outgoing inspection must still be performed between tenant and landlord or their agent on their behalf.
So there's going to be a potential sort of overlap when it comes to these forms and the defects list that you've got on the property, because now you've got this mandatory disclosure form that's attached to the lease agreement. But furthermore, you're going to have your incoming inspection that is also going to speak to damages or defects on the property. So it's going to be quite interesting. I would suggest, in a way, from a practical methodology, is to get that list and that form as quickly as possible.
Well, it has to be done before the mandate.
Before the
is signed.
mandate. And to inspect the property yourself as an estate agent to establish whether that form is actually correct or not.
Well, I don't think we want to put any extra duties on the property practitioner. Ultimately, it is the owner, the seller's responsibility to ensure the accuracy of that disclosure form, because, Peter, I've got two questions.
Yes.
Question number one is, what happens if the estate agent or property practitioner does not add this mandatory disclosure form to the mandate and to the offer to purchase? What is the property practitioner opening themselves up for?
So the property practitioner could be held liable by the consumer, which means obviously the potential tenant on the property or the potential purchaser of that property. They could be held liable for the damages or defects on that property if they have not been given or garnered that mandatory disclosure form by the owner of the
So
property.
I've got a fabulous example. My sister-in-law and her husband recently bought a house. They moved in December. It was fabulous. And then in January, the rain started. And the roof leaks. It leaks it's like a sieve. There was no disclosure form. And could they rely on latent or patent defects in this regard?
Michelle, latent and patent defects, let's go back to a little bit to foot stewards, if you wouldn't mind. Okay, we've still got the foot stewards clauses in terms of the offers to purchase that says that the property is sold as is. Latent and patent defects is a little bit different, because a latent defect is something that you cannot necessarily pick up, or an ordinary person when they're walking through the property cannot pick up. So it's a possibility that it could be leaks, even though we've had a lot of rain in the last 2 months in Gauteng. So it might not be a latent defect to say that the property is not busy leaking. We could have a legal argument. Your sister can contact us. Sorry, your brother can contact us about that. But a patent defect would be something that is specifically apparent on a property. So you can actually see, okay, the door handle's broken or the window's broken. But with latent and patent defects, I think it's actually going to protect the estate agent a little bit with this mandatory disclosure form, because at the end of the day, the owner of the property is going to mark whether he knows something is broken or whether he knows something has a defect in or not. And those acute not just to latent, but also patent defects on the property.
So I think that the message that we're giving at the moment is, yes, it's more administrative work, but it is protecting the property practitioner from any future damages claim, because the landlord or the seller have drafted this disclosure of any defects in the property, and therefore any defects that become apparent after the fact would be the landlord or the seller's problem for not disclosing.
Yes. Just from a little bit of an administrative, because you said now it might be a little bit more administratively burdensome, but through the e-sign platform, there's no indication in terms of the Act or regulations that that mandatory disclosure form cannot be signed electronically. So with the mandatory disclosure form through e-sign, you could actually supplement that and send that through to your landlord prior to, or rather owner of the property or seller of the property, prior to the mandate being sent through to them. So it actually makes it a little bit simpler through e-sign to go and utilize that, go and
Fantastic.
do that.
I think that brings us to the end of those 4 sections that we wanted to deal with today. Jade, if we could jump across to you, and I'm sure we've got some questions that Peter's going to need to address.
We have a plethora of questions, Mish. I've just posted the feedback form, so it is available. Please complete it. Okay, first question from Richard Abrams. Do people who are employed by the landlord entity need to be registered?
So the landlord entity. So what we're saying now is that sorry, I'm just making sense of this question so that we get this perfect, is that the landlord, and that would be the owner. Interesting question here, because a landlord could not be the owner of the property.
Could be a sublease.
It could be a sublease. So from the question of a landlord, it's very possible that the individual parties who is renting out the property or assisting in the sale or negotiating that would need to be registered as property practitioners, very possibly.
Peter, it would be the same as the attorneys.
Yes.
So where you have an attorney firm, the attorney and the candidate attorney do not need to register. But
Yes.
when the person is performing the functions of hiring, letting, selling, or managing the property, that person needs to register as a property practitioner.
Most certainly, Michelle.
Yeah.
Okay. Question from Brian van Wyk. Peter mentioned homeowners associations. Please clarify whether they must register.
Yes. Most certainly the homeowners association or the person that manages the homeowners association, so we call this a managing agent. It's also been defined in terms of the regulations, would need to register, and obviously when it comes to registration, it's quite interesting in terms of the regulations, because you've got this a business property practitioner and the property practitioner. So the business, the closed corporation, the PTY Limited that is managing the properties on behalf of the body corporate or homeowners association.
And all the directors
and
or
all
members.
the directors, members and trustees of that entity would need to register. And
as well
obviously
as the people.
the employees.
Yeah, yeah.
The people, or let's not say all employees, let's rather say the people performing the acts of a property practitioner in terms of the Act and regulations.
And the Act does define both homeowners association and sectional title deeds.
Yes.
Okay, I have a question from Anna. She needs more clarity, please. She says this is her scenario. A private company has a block of flats that are rented out. Does the company have to register?
So the private company owns all of
Yes,
those flats?
Correct.
Okay, so that would be a scenario of you renting out your own properties in the ordinary course of business, and that's been captured in Section 1, that it is an exclusion that you would not need to register as a property practitioner.
Okay, we have a few questions about intern agents. Question from Chantal Becker. Do intern agents have to be registered?
Yes, they would. They are now called candidate property practitioners. Their fees are also a little bit different than a property practitioner in terms of the regulations. There's a number of things that a candidate property practitioner now also needs to do. They're going to do away with the logbook system that we've currently got. They would need to run through 12 specific modules of training, whether that be sales or leasing. We're still going to need to find out about that a little bit, because any training authority could be a different business that registers themselves with the property practitioners regulatory authority. They're going to need to run through those, through those 12 modules and then write their CPE exams and then become a full property practitioner. But that is also, there's a lot of regulations attached to candidate property practitioners. Also, that you need to do that specific module system throughout a period of 18 months rather than the 3-year time period that your Fidelity Fund certificate is going to be valid. But if you've got more questions on that, you're more than welcome to email me and I'll delve you into the entire process of becoming a full property practitioner.
Thanks for that clarity, Peter, because there was a lot of questions regarding logbooks. I hope that's been answered now. Quick question from Stain Realty. Where do we get a copy of the mandatory disclosure form?
The mandatory disclosure form is available on the sales pack, on the residential and the commercial lease pack. Some of you might remember from the current residential documents, we had a disclosure form already that just said landlord's disclosure form with estate agent and without estate agent. The reason for that is because there were directives from the Estate Agency Affairs Board, I don't know, about a year ago or so, that said that they would recommend, and Rebosa also recommended this, that this occur not just on sales but also on rentals. So we've now just condensed that. We have deleted both the landlord disclosure form with agent and without agent, and now it's just called the mandatory disclosure form. So that's the document in all of the different packs that you can go and utilize to be compliant in terms of the Act and regulations.
And how our clients go and do that is they log into shop.tpn.co.za and they just, if you're not already a lease pack member, then register and subscribe as a lease pack member. And if you are, then just log in with your login details, your TPN login details, and you can download the mandatory disclosure form. We put it right at the top. Actually, we've put it in the mandate section.
Good.
So the section that has the leases and the mandates, the mandatory disclosure form is now included in that section as well.
Okay. Another question that has come up a lot, I do think you clarified it in training, but I think no problem with reiterating. How do we get a landlord who lives abroad to sign the mandatory disclosure form?
E-sign.
Michelle, you said it. TPN developed about 4 months ago or so an electronic signature platform
make it
and
sound
tool
so simple.
repository. It's very simple. It's incredibly simple.
You make it sound so simple, like we developed it 4 months ago. No, it was 18 months of slog to get it into the system.
The development process was long. It's easy to use. So you can access that directly from the TPN shop. You can just click on the eSign button up at the top, as well as esign.tpn or tpn.esign.co.za. But with all the documentation that you've currently got available on your residential or commercial lease packs, remember, you can't do these on sales. Vitally important to mention that you can go and utilize that eSign platform, and that's very simple. I mean, you really go and select the document that you'd like to use. You go and complete certain of the fields that need to be incorporated in the contract, in the mandatory disclosure form, and then through a link, that prospective landlord, or that landlord rather, is going to get that link. He can go and fill it out and sign it directly through that platform. It also works as a document repository system, so it's going to save those documents for you.
For the 5-year retention period that you're required to save the documents for as well.
Is vital.
Yeah,
Yes.
absolutely. So the e-sign, Peter, just to confirm, e-sign electronic signature can be used on all the residential and all the commercial documents. It can be used on the mandate and the mandatory disclosure form on the sales
Correct.
pack, but we can't use electronic signatures on the offer to purchase because that needs to be a wet signature. in terms of the law.
100% correct, Michelle.
Okay,
Yes.
perfect.
Okay, I have a question from Peter Weyman. Would you need a disclosure form for an open mandate where the seller has appointed more than one agent to market his property?
Yes, most certainly. So, Michelle, you hate this word, but unfortunately, with the Act and regulations, there is not a distinction between open mandate, sole mandate, procurement mandate, or management mandate. So for all mandates that you undergo, whether it's be written, whether it's verbal, whether it's tacit, you're still going to need those landlord disclosure forms, rather than mandatory disclosure forms from the party.
But an exclusive mandate is required to be written.
Yes,
And
Michelle.
it is required to
Yes.
have an end termination
Yes.
date attached to
Yes.
it. An open mandate can be verbal.
And that's still in terms of, I mean, that was copied directly from the Estate Agency Affairs Act. It is still in the Property Practitioners Act that a sole mandate or a closed mandate or a management mandate must be in writing and needs to have a specific termination date in that agreement. Yes.
Okay, I have this question that's come up a lot of times as well. This specific one comes from Carmel. But is the Act retrospective? Do current lease agreements need to be updated?
That's a great question. No. It would, yes, be effective from the 1st of February, but what we always suggest with new pieces of legislation is that on renewal of the contract, specifically your lease agreements, you utilize the new documents. Don't go and sign a renewal addendum. Just download the newest document from the pack and utilize that as the contract going forward. But you're not going to now need a mandatory disclosure form for a lease agreement that has been or was entered into prior to the Act coming into place. What I would, however, suggest is your mandates are also going to have to be renewed at some point in time. Sign a new mandate agreement, and at the point in time of signing a new mandate agreement, you get the landlord to sign a mandatory disclosure form and fill out the conditions and defects on the property from that date onwards.
Okay. Question from Sandra Kutso. Who is signing off the mandate in office?
The
So
mandate in office.
I assume this is in the property
Yes.
practitioner's office.
It would not be the candidate property practitioner, that I can tell you. So it's going to be your property practitioner that has a valid Fidelity Fund certificate is going to sign that mandate agreement between the parties.
Okay, I have a question from MC Widowmaker. If I lease out property on behalf of my parents without remuneration, do I need to register?
No, you would not need to register.
The important distinction here is whether you receive remuneration or not.
Correct.
I know some families that the families have, all the siblings have properties, and then the one sibling is the property practitioner and does receive remuneration for managing all of the siblings' properties because the portfolio is quite big. In that instance, that sibling would be required.
I think the importance here also with the Act now, with the Property Practitioners Act, they've included sections on consumer protection. And the Fidelity Fund certificate is there specifically for consumer protection. So if it's a once-off and you're just busy doing it for your parents, renting out the property without remuneration, no, then it would not be applicable.
So we have a few scenarios that have been asked, such as if my husband is the owner of a property and I, as his wife, manages the property and I make money from it, would I still need to register?
Yes, you would need to register as a property practitioner and have a valid Fidelity Fund certificate and follow the entire process that we just talked about.
Okay, so another play on a similar question from Agora Capital Investments. If I work for the owners, I manage their property purchases, their tenants, rent and maintenance. On their behalf, do I have to register?
Yes, it would seem so. As you've just asked the question, just taking it very simplistically and sort of just reading it as you've said it, yes, you would need to register as a property practitioner.
Thank you. Okay, I have a question from EDPF. With regard to BEE certificates, is there a minimum BEE level requirement or does even a level 8 make one compliant?
That is a very good question. There is no minimum requirement in terms of the Act or regulations. They have included that they may make minimum requirements through regulation as it's being gazetted, but for the moment there's no minimum requirement on this.
Great. I have a question from Bram Basson. What about property inspectors, move in, move out, maintenance, and assistance to rental agents?
It is very possible that that entire profession is going to be encapsulated in terms of the Property Practitioners Act, like we said in the definitions, in terms of Section 1. What's also very apparent in terms of the Act is that they took this into consideration. They took into consideration that there is going to be a number of different professions that is going to be impacted as a result of the definition being so broad. Specifically in the regulations, they speak to that the specific professions or their regulatory bodies would make different rules, different codes of conduct, perhaps even have different Fidelity Fund certificates for those specific parties. But as it reads currently, yes, they would need to be compliant in terms of the Property Practitioners Act.
Thank you, Peter. This question has also come up a lot. Question from Tara Morris. If you have a valid FFC for 2022, will it be valid for 3 years or must we apply for another one for 2023 that will last for 3 years?
It's going to be valid up until the end of this year, and you're going to have to do your registration through the Property Practitioners Regulatory Authority before the 31st of October of this year.
Also, Peter, just to make a note there, even though your Fidelity Fund certificate, once you register with the authority, is valid for a period of 3 years, you would still need to do annual submissions.
Correct,
So your annual trust account audits, financial review audits, your BE certificate and your tax clearance certificate would have to be submitted on an annual basis, even though your FFC is valid for 3 years.
That's correct, Michelle. Yes.
Okay. I have a question from Edgar Judgy. He's asking, are foreigners prohibited from working as estate agents? Can they register as property practitioners under the new Act?
So we had this discussion this morning, me and Michelle as well, but what they've included in the Act is the word may. So that's very important. So it is really up to the Property Practitioners Regulatory Authority to make a call on that. It would seem as if those are the conditions attached to exclusion, but the word may has been included, not must. So no. On that specific question, the Property Practitioners Regulatory Authority really has the power when it comes to making those determinations for exclusion.
Okay. I have a question. How does the Property Practitioners Act affect property sourcing and canvassing?
So property sourcing and canvassing, that's an interesting one. So a person that is, let's say, appointed by a property practitioner or by an owner to source certain properties
would have to be registered as a
I would think so as well.
practitioner.
Yes,
Absolutely.
Michelle. Yes.
It does say that, yeah. It's very clear, in fact, in section A1.
Okay.
Yeah.
Great.
Okay. A question from Alicia. Who will be the Property Practitioners Regulation? Is it still the EAAB but renamed? Is it the same portal on the EAAB and the same process?
I'm glad I read this Act in so much detail. So they've got transitional considerations as well in terms of the regulations and in the Act. This is actually directly from the Act. But the Estate Agency Affairs Board, they call it disbanded and disestablished in certain instances. But the board, as it currently stands, will move over into the Property Practitioners Regulatory Authority. Any employee by the Estate Agency Affairs Board will become an employee of the Property Practitioners Regulatory Authority. There's just a different constitution of the board as they've currently got, but those positions will obviously be filled throughout the next couple of months when they determine perhaps a different CEO. I'm not 100% certain how that arrangement's going to work, but basically what's going to happen is it's going to be a rebranding of the Estate Agency Affairs Board, even though it's disbanded, into the Property Practitioners Regulatory Authority, with some different conditions attached to board involvement, the responsibilities of the board, specifically having a look at transformation, the transformation charter, or the property sector transformation charter, including the grant money and everything and how that's going to be regulated, is also a little bit of a difference. But the Estate Agency Affairs Board is going to be swapped over into the Property Practitioners Regulatory Authority. We can say swapped over, yes.
I have a question from Nicholas. This is another question that has come up a lot. Is CPD being done away with?
No, there's still going to be your continuous professional development in terms of the Act. That still needs to be complied with.
The change there is that it's not all going to be run under the Estate Agency Affairs Board or now the authority. Business can now apply through CETA to be accredited, and business can now start to issue CPD points. So it's not contained solely and exclusively and monopolized by the board.
Okay, we have a question from Ancora Real Estate. If you keep rental deposits, do you require a trust account?
Yes.
Most certainly, yes. And audited.
That doesn't even require further deliberation, just yes.
Thank you. This question's also come up a few times. Do property managers and admin people in property practitioner offices need to register?
Yes.
Most certainly, yes.
Okay. These are quick answers. Okay. What if you are a remote working business with no offices?
Interesting one, but still a property practitioner, regardless of where you
operate.
Just an interesting one. I knew we weren't going to necessarily get into this in the conversation today, but with regards to inspections, that is going to be a difference because a inspector in terms of the Property Practitioners Act may enter any business premises without a search warrant. To have a look at certain documents, ask for your Fidelity Fund certificate, and perhaps even make copies of those. But for a place of residence, they are actually going to have to notify you.
So if you operate your business from a place of residence, the inspector can't enter your
without
home
notification.
Without a search warrant.
Yes.
But if you operate from an office, an inspector can, without notice,
100%.
enter.
100%, Michelle, yes.
This is a question we may need to take offline from Adele Fulyun. Would a BEE affidavit suffice, or would you have to be certified for BEE?
It would seem to me, in terms of the Act and regulations, that you're going to have a BEE certificate.
The regulations speak to a valid BEE certificate.
Yes.
So if you have an affidavit because you're below the threshold, one imagines that you would use that affidavit thereby to get your BEE certificate.
So we are jumping around from topic to topic. I have a question
Keeping us on our toes.
There's so many questions coming in. I have a question from Colette Resin in regards to the mandatory disclosure form. If the seller doesn't know the property's latent or patent defects, is an email stating they don't know the conditions of the property acceptable?
No, most certainly not. I would suggest that they get a third party to go and have a look at the premises for them, hopefully a trusting third party, and then complete that mandatory disclosure form. It is a requirement. You can't just do away with it.
So this would be the same answer, because I have a question from Louisa asking if an investor has not been to his property in years, how does he complete the disclosure? So he just then send off a third party.
Trusting third party.
Trusting
yes.
third party. Okay, this question has come up a lot. Question from Mark. Is the mandatory disclosure form required for both commercial, industrial, and residential properties, or is there an exclusion where it is not required?
There's no distinction between rentals or any type of sales in terms of the Property Practitioners Act. So commercial brokerages would also need to complete for industrial, commercial, or retail premises that mandatory disclosure form.
Thank you. We have a question from Dirk. Is there an example of the disclosure form?
Yes, on the shop. Please log in, shop.tpn.co.za. Go download it. Or if you want to go into the regulations in page, I don't know, whatever, in the regulations, you can go find it over there.
Okay. Question from Sasha Kun. Is the disclosure form required for a relet or only with a new mandate?
So this is sort of the same question as whether your agreements now need to be updated and send out all your new leases and mandates. We would suggest on renewal of contract that landlord disclosure form be completed. Use it as a good opportunity to perhaps to get your mandates updated as well at that point in time.
Absolutely. It's never a bad thing to get your
No.
administration in order.
Most certainly not. We always say rentals is 98% admin. So
yeah.
Okay, that's all from my side
Let's
for
wrap it
now.
up. Fantastic. Peter, I think then on that note, let's close off with the fact that the docs are there. Shop.tpn.co.za is a place to go get them. For our clients that are already members, they simply log in and download them. There's no additional cost.
Yep.
And of course, the e-sign comes at no charge either. So you're able to get your documents electronically signed. Right now, today, let's get going. For our clients who are not yet on the shop, they would go to shop.tpn.co.za and they would choose whether they wanted to be a residential lease pack member, commercial lease pack member, or a sales pack member. And then all the documents are included in each one of those different packs.
wonderful. And I think the legal team's not going to be too happy about me saying this. But if you've got any further questions, please remember you can send those emails directly to helpdesk@tpn.co.za. And if it's a specific legal query, go to legal@tpn.co.za. Myself, Greg, or Jade would get back to you as quickly as possible.
Thanks, team. Thanks, Peter. Thanks, Jade.
Have a great day further, everyone.